sealed, it may be impossible for the child to prove who his genetic parents are, and vice versa. So that's another whole issue to think about. You may not be able to determine genetic lineage if those records are sealed, and then that requires the child to, any number of court hearings to see if they can get those unsealed. Okay. Any questions on those rules? Here's the thing I want you to think about. This is kind of stepping back from adopted children and just looking at the course we're looking at. I don't know how many of you have had a question up to this point that says, well, why should I have a lawyer draft my will if I can just get one off online? Anybody? No one's heard that yet. Okay.
I wrote a paper about it for a different class.
Okay. Guaranteed you will hear it at some point. Well, I can download it. Or there's that law firm that kind of is online. Isn't it the guy who did
Legal Zoom or whatever?
O.J. Simpson's trial, right? And then he's since passed, but his law firm does all this online stuff, right? Here's the answer you give to people, okay? And think of all the questions you're coming up with. And one of the reasons I try not to dismiss good questions, even if they're a little bit off what we're talking about, is because you're thinking about what ifs. That's what we get paid to do, really, right? I mean, sure, anybody could fill in a basic will. I leave this to this person, this to that person, et cetera, et cetera. But we deal with what ifs. We deal with simultaneous death. We deal with, well, if you get divorced, actually, you really should be redoing your will. But we're going to deal with all the what ifs. And that's why well-drafted documents and good estate planning attorneys are going to sit down and have a fairly lengthy survey for you to fill out and then a discussion. Because you want to think about all the potential circumstances and say, okay, but if this happens, do you want this to change? Right? You might have mirroring wills, but at the instant of one person dying, do we want that to change? Who do you want to take over as successor, trustee, et cetera, et cetera? And then you got to think, well, what if everyone is predeceased? That's we call kind of the ultimate beneficiary question. So I wanted to make that point. I meant to make it in another class. Someone else asked me a question. There are a lot of things that a well-drafted, and I should say testamentary document, because that could be a will and a trust, can deal with that. An average person, even if they're intelligent, an average person, having not sat down and looked at all the problems that can ensue, would not think about. And that's our role. That's the whole reason, at least I would argue, that attorneys should be paid. Okay. Not paid, but do work. Okay. Let's talk a little bit about, luckily we're getting to, there we go. Okay, suffice to say, if they take our room again, I'm just not going to have class. Now I have no. There we go. Okay. There's no room up here either. Let's talk about adoption of adults. It's an issue that arises, and we'll talk about actually how sometimes it can be strategic. The majority of states' laws are not going to differentiate between adoption of a minor and that of an adult. They're not going to specify between, they're going to talk about a parent-child relationship, but they're not going to say that it's a minor child or a child under a certain age. Okay? A majority of the states, believe it or not, allow adult persons, married or unmarried, to adopt another adult person, obviously a minor, but an adult. But then case law usually adds in a little flavor, for lack of a better word. So, for instance, there's New York law that's mentioned in your text, at least in some of the notes, that says you can't adopt someone with whom you have a sexual relationship. So, I guess you can adopt your best friend if it's platonic, but if it's someone else, not. Okay? And they, at least in the New York case, and cases in other states have said sexual relationship is incompatible with a parent-child relationship. Okay? That's probably a good statement to make. Okay. But I just got done teaching in Delaware, and there was a Delaware case whereby, and I think we're going to read a case at some point along the way, although it's not in this area of the course. It's a 1993 case of the Delaware Supreme Court, and obviously I teach it I used to teach it because I also taught bar review, and they liked weird questions on the bar. But a 66-year-old man adopted a 51-year-old man, his companion of over 17 years, to prevent claims against his estate by collateral relatives. Again, what are collaterals? Siblings, nieces, nephews, potentially cousins, aunts and uncles, things of that nature, or people of that nature. Okay? So, why is adult adoption in that situation? If you're in a non-traditional relationship, it is one way to ensure inheritance rights. And as we all know, those inheritance rights for children are going to trump anybody else's claims. Yes?
This may be a weird question, but if you're, in your hypothetical, what if the 51-year-old wanted to adopt the 60-year-old because he's going to die first, hypothetically, he's older, but he wants to give him his inheritance rights in case something happens? Can you adopt up?
Well, yes, absolutely, he could have adopted up. I think the question that I thought you were asking, that I'm not sure about the answer to, is, since the 66-year-old went first, does that mean the 51-year-old can adopt back? Is that what you're asking?
No, but now I am.
Okay. Okay. Yeah, I opened that door, didn't I? I don't know the answer to that question. I have to think about that. Because then you're each the parent and child of each other. That's kind of a weird situation. I mean, well, for lack of a better word, it's not an ordinary situation, right? Clearly, the 51 could have done it first. I don't think there's any question that that's a correct answer. Whether or not they both could adopt each other, I'm not sure about, so I'm going to have to get back to you on that. Okay. So you can look at that as kind of an aberration, or you can also look at that as a little bit of a sad situation, that is the only way in which they felt they could ensure inheritance rights, right? And actually that wasn't all that uncommon until we've seen a little bit of a different approach to non-married individuals. Yes, I saw another hand.
All right, I was going to ask if this would be a possible solution for the same-sex relationships. So, like, if there, I think in this case, if I read it correctly, that there were two men who were partners.
Right.
And the 66-year-old adopted the 51-year-old. Does that mean that they still had a continued sexual relationship, so they couldn't actually do that?
Oh, okay, I see what you're asking. Delaware didn't care about the sexual relationship.
Okay.
New York did, which seems kind of backwards, right? You would think New York would be like, whatever. But, the Supreme Court sits in Albany, not in New York City. Maybe that's the difference. I don't know. And, having lived in Delaware for 8 years, and even though it's the East Coast, people always think, it's the Mid-Atlantic, it's not Northeast, it's not New England, so it's not all as liberal, I think, as people think. But anyway, but Delaware is fiercely kind of live and let live, so the court just did not believe the sexual relationship part, because it was adults, was enough of a reason to prevent the adoption. But you might ask yourself a question, since we're talking about it, it's kind of an is, okay, so how would they know anyway, right?
Yeah.
So that's that's the other question. I'm not really asking for answers. I'm just throwing out the question. Okay. Anything else? But you're right. It's actually not was not an uncommon estate planning technique at all.
Yeah. So procedurally, if a collateral family member or whatever wanted to attack the will, is that when they would assert this whole lover problem? Not at the time that the adoption takes place, but after the fact?
Right, and if I remember correctly from the case, having read it a while ago, he adopted the younger partner and then died without a will, believing that it was harder to fight the intestate scheme
than it was the... Gotcha.
Which is actually brilliant if you think about it. I mean, brilliant from a legal perspective. A lot harder to attack an established intestate scheme. So that's why the case was so important, because it allowed you to adopt and just say, he's my only child, I have no surviving spouse, my parents are dead, he gets everything.
Wow. Okay.
If you do a will, you're absolutely right, you're opening up. And that is always the problem, is that whether you agree or disagree, right, with people making those decisions in their life or whatever, but the problem was a good will and trust doesn't mean that you can't still be subject to a fairly strenuous and a fairly painful will contest. And so, a adoption followed by intestate death was almost a foolproof way, except, of course, New York disagreed, yeah.
Yeah, so in that particular case, his option might have even been better than creating a trust and naming his partner a beneficiary in that case.
Right, exactly. Remember, this is 1993. It came out of the Delaware Supreme Court, meaning it had been in the court system for a while. So in the late 80s, absolutely.
Wow, okay. Not today. Today, it'd probably be
No, I think today you're going to find that designations of same-sex partners for healthcare directives, powers of attorney, and trust
yeah.
are going to be held fast. But unfortunately, what you found was that court systems couldn't separate what they believed to be, right, kind of family trumping what they really looked as a non-relationship, right? And so I don't want to say their own morality came into play, because I can't speak to that, but I think you could not be sure your documents were going to be withheld. Let's put it that way. Absolutely. So I think actually a fairly brilliant, and I heard the attorneys speak to represent them, and that's exactly what they were thinking. They knew they were going to be fought, so let's just take advantage of the much established, over 100-something years established, intestate statute. Done. Okay. With some amendments to the statute, but the statute had been in place for a long time. Okay. Let's see where I'm at. Okay. The other thing I want to talk about briefly, and then we'll go ahead and break, is talking about adoption and wills and trust interpretation. And this is a theme we're going to see as we go along, so this is kind of a good way to end, and I'll probably let you go a little bit early. In most states, adopted children are included in gifts by the testator to children, right? Or issue, or descendants, or heirs. So now we're looking at written documents. We're not looking at what we mean by children under the intestate statute. We're looking at the written documents. Okay. But what happened was, in a lot of instances, where if you just put my children, and you did have adopted children, in some instances, it did produce case law, like we had to read on page 103, that particular case. And what courts are sometimes left with doing is, if they can't determine what the testator meant in a document with reference to a particular term, they would go ahead and look to the intestate statutes and the state already having interpreted those in case law to basically impute what the meaning of that term was in the will. So that's another thing to think about, right? Even though you have a will or a testamentary document, you've got to think about the terms you're using and make sure that you're defining the terms the way you believe it should be, and not automatically assume that everyone understands that children equals adopted children, right? So that's another kind of point that we're going to look at in a little bit more detail. But why don't we go ahead and break at this point, and then we can get into virtual adoption and all that stuff when we come back. Because I don't think this clock's a little bit later than that clock. I don't know. But we've hung out for an hour. We'll go with that. Okay. I'll see you Monday in our regular bat channel, bat time, bat place. Okay. That's it. We'll pick up it and hopefully finish up topic 6. Okay. Oh yeah. So if I distribute any problem sets or something of that nature, I'll split them up and good. Yeah, and then just if you can always feel free to just touch base with me. Any questions? What I try to do, I know I kind of a lot of times scrapped out assignments in class, 2 classes. So that's kind of one way, but if, like I'll put up what we're going to do for Monday. So if you miss Monday, yeah. Okay. fair enough, right? We will miss. So you'll know what we're going to be doing that Monday based on this Monday.
Craig.
Perfect. I just always say to Sue, she can text me, check in. But you can just shoot me an email.
We will one day, Greg. When you own every transportation